We have a very important but geeky video about understanding why the government bears the burden of demonstrating that an arm they're trying to ban, whether it be a magazine or AR-15, the burden of proof is on the government to demonstrate that they're not in common use. And I want to address a myth advanced by the anti-gun community about a critical language out of the Bruen decision and how you can rebut this fake news by the anti-gun lobby. Stay tuned. We're going to get geeky. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, well, I'm in a suit today, again, because Fox News is keeping me busy with all this Trump stuff. A very exciting time. Let's keep our fingers crossed for November that we get rid of the anti-gun Biden administration, but only time will tell. See what happens. All right, so we want to talk today about a common myth that the anti-gunners are trying to advance, which is they're trying to say that the Bruen decision stands for the proposition that the in common use test, meaning that an arm is protected if it's in common use by Americans for lawful purposes, that level of analysis occurs at the textual level as opposed to at the historical level. Now, as you know, it's extremely important. I repeat, it's extremely important that debates about whether or not an arm can be banned occurs at the historical level. And why is that? Because as you know from the text first, burden shifts to the government, then historical analog analysis. The burden of proof is on the government when you're in the historical analog portion of the Heller-Bruen interpretive methodology of the Second Amendment, which is plain text first. If the modern gun control law is implicated by the Second Amendment's plain text, which they almost all are because they're gun control laws, the burden shifts to the government to say, well, your gun control law is unconstitutional unless you can show that specific gun control law is part of a long-standing, well-established tradition going back to the founding of some form of gun control that the founders would recognize and all that. And that is virtually impossible for the anti-gun movement to do for many reasons. But when you're dealing with an arms ban case, the Supreme Court has already done the textual and the historical analysis and concluded that whatever you want to say about the scope of the Second Amendment, the one thing that is crystal clear is that if a type of arm is in common use by Americans for lawful purpose, it cannot be banned. There may be other reasons why you could not ban an arm, but for our purposes today, where we're dealing with magazines that hold more than 10 rounds that are owned by the hundreds of millions, or AR-15s that are owned by the tens of millions of Americans, these are clearly in common use. So these are simple and easy cases for us to win. It's especially true given the fact that the government bears the burden to show that magazines that hold more than 10 rounds and AR-15s are not in common use, which is simply impossible for them to do. That's why they're so desperate to try to avoid the burden shifting to them to show that these are not in common use. Now, there's a critical language that I'm going to quote for you here from Bruen that the anti-gunners are trying to say somehow means that the in common use test occurs at the plain text level where the burden of proof of pleading is technically speaking on the Second Amendment proponent. But this is simply not the case. So I'm going to read this language to you from Bruen. I'm going to tell you how it's been misconstrued, and then I'm going to give you further support to show that my understanding and my interpretation of how this really works is absolutely consistent with what the Supreme Court says, and that the anti-gunners are trying to advance a myth. So specifically, let's turn to the critical language from Bruen that the anti-gunners are trying to use against us in arms ban cases. Bruen said, quote, "It is undisputed that petitioners Koch and Nash, two ordinary law-abiding adult citizens, are part of the people whom the Second Amendment protects. Nor does any party dispute that handguns are weapons in common use today for self-defense. See Heller, see Caetano." We'll get to that in a moment. "We therefore turn to whether the plain text of the Second Amendment protects Koch's and Nash's proposed course of conduct, carrying handguns publicly for self-defense." Now, this language I just read for you has been widely misinterpreted by the anti-gun community, on purpose presumably, to mean that the in common use test is at the plain text level. Now, you can see anti-gun judges in some of the oral arguments on arms ban trying to suggest this is the case. But as I see it, this is a blatant misreading of that Bruen passage, which really, if you read it carefully, it actually supports our argument. You see, when the Bruen court said that the handguns are in common use, they said there's just no analysis. Everyone understands that these are protected arms. That's what the Heller case has said, and that's why they say no one disputes that handguns are weapons in common use today. Period, full stop. They're protected. And for that reason, the court says, in light of these basic understandings, we're going to now move on to the plain text analysis of the word bear, which is what the Bruen case was about, is whether or not the word to keep and bear arms meant that you could carry handguns in public as a matter of constitutional rights. And they said, yes, the right to bear arms means you can carry guns in public for all lawful purposes, including self-defense. So they didn't need to get into the debate of what arms are protected because they said it's already established that handguns are in common use today and are thus protected by the Second Amendment, period, full stop. Now, in light of that, what the anti-gunners are trying to say is that paragraph somehow means that the handgun, or I should say the in common use test, is part of the plain text analysis, but that's clearly not true. Again, if you look at the language, the first part of it talks about handguns being protected, and then the last part is in light of all this, we therefore turn to the plain text of the Second Amendment, whether or not it protects the Bruen plaintiffs' right to carry guns outside the home. Now, this is where we're going to get super geeky. If you look specifically at the citations that Bruen cites to, when they make that statement that handguns are weapons in common use today, and there's no dispute they're protected, they cite to two different cases. They cite to the Heller case, page 627, and this is where we're going to get geeky. Specifically, if you look at 627, we're going to look at page 627 of the Heller decision, you'll see that entire discussion is about, you guessed it, historical analog laws. It has nothing to do with the text. Then that same provision in Bruen cites to Caetano versus Massachusetts at pages 411 and 412 of those opinions. And again, when you turn to that, and we're going to do that in 1 minute, you'll see that all that discussion is about, you guessed it, historical analog laws, not having to do with the text of the Second Amendment, the plain text of the Second Amendment, where the burden is arguably on the Second Amendment proponents to show as a matter of pleading that the modern gun control law is implicated by the text of the Second Amendment or vice versa. No, you'll see that the relevant pages cited for that proposition that handguns are protected today, both in Heller and Caetano, specifically deal with historical analog laws, which proves my point that the issue of dangerous and unusual weapons and the converse, that if it's in common use, it's not a dangerous, unusual weapons. That's part of the historical analog analysis of the text first, burden shifts to the government, historical analysis second. And again, this is mission critical to understand because it's the difference between winning and losing arms ban cases in many instances, because when the burden shifts to the government to show that magazines that hold more than 10 rounds or the AR-15s or AR style or AR platform firearms are not in common use, they're not able to do it because it's clearly not true because of the millions and millions and millions of guns and magazines that are out there like this, which is why they want to ban them because they're so popular and ubiquitous. So anyway, but let's go down and take more specifically look at the specific pages cited by the Supreme Court in Bruen for the proposition that handguns are protected today, just as a matter of fact, constitutional wise. Well, let's turn to page 627 of Heller. If you look at page 627 of Heller, which is the page number specifically cited by Bruen for that proposition, here is what the Heller case says on page 627. And you will see it's all about history, historical analog laws. Let's turn to it right now. Heller said on page 627, quote, "We also recognize another important limitation on the right to keep and carry arms. Miller said, as we have explained, that the sorts of weapons protected were those in common use at the time. We think, listen carefully, we think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons." The Supreme Court then goes on to cite a whole host of historical treatises summarizing historical laws, Blackstone, Wilson, Russell, and so on and so on. So as you can see, Page 627 of Heller, which is what Bruen cites to when they refer to the handguns being protected weapons, and there's no dispute about this, is all about history. This is important because, again, at the historical level, the burden is on the government to show that an arm is not in common use or that an arm is dangerous and unusual, which means they have to show it's not in common use, because if it's in common use, it cannot be dangerous and unusual, which is a conjunctive test. But now the other thing to keep in mind is the Bruen case also cites to Caetano versus Massachusetts, pages 411 and 412 of the U.S. reports. And these page sites, by the way, I'm using are from the United States reports themselves, the official reporter of the United States Supreme Court. Now, if you turn to those relevant pages in the U.S. reports of that opinion of Caetano versus Massachusetts, what also will you see? Indeed, you will see exactly what you would expect to see, which is a discussion of the historical analog laws governing so-called arms ban cases, because it's all about the history. And we want it to be about the history because, again, at the historical level, the burden's on the government to come forth, and the burden is on them to show their modern-day gun control laws are constitutional. And when they ban arms, it means they have to show at a minimum, that the arms they're banned are not in common use, which they simply cannot do in the AR cases, AR platform cases, or magazines holding more than 10 rounds. So let's turn to Caetano. To begin with, Caetano starts off stating that the Second Amendment protects all bearable arms. Specifically, the Supreme Court writes in Caetano that the court has held that the Second Amendment extends prima facie to all instruments that constitute bearable arms. Well, that's just setting up the issue. As you remember, Caetano was about the Massachusetts state's law that banned stun guns, and the Supreme Court said that the Massachusetts Supreme Court, in upholding that stun gun ban, did it all wrong and likely violated the Second Amendment. But beyond that, for our purposes of today's video, the Supreme Court in Bruen, talking about handguns being protected, cites to pages 411 and 412 by Caetano, and if you turn to those pages, you'll see they're talking, yes, about the historical analog laws, which means the burden is on the government. Here's what the Supreme Court said in Caetano, the same pages relied upon by the Supreme Court in Bruen when they cite to this dealing with handguns being protected by the Second Amendment. The Massachusetts court next asked whether stun guns are dangerous per se at common law and unusual in an attempt to apply one important limitation on the right to keep and carry arms, citing to Heller, specifically referring to the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Now, in doing so, the Massachusetts court concluded that stun guns are unusual because they are thoroughly modern inventions. But by equating unusual with in common use at the time of the Second Amendment's enactment, the court's second explanation is the same as the first. It is inconsistent with Heller for that same reason. So there you have it. The pages that the Bruen court cites in Heller and Caetano all talk about history. And this is important because, again, the burden's on the government when you're dealing with historical analog laws, which means by extension, because the in common use test is part of the historical analog analysis, guess what? The burden's on the government to show that AR-15s, AR platform guns, and yes, magazines that hold more than 10 rounds are not in common use, and they simply cannot do it. So when you're talking to anti-gunners and judges that are either ignorant about this or feigning ignorance about this, and they try to use that language out of Bruen to say, see, the in common use test arises from the plain text level, well, you tell them that's not true. Not only does the relevant language in Bruen indicate that's not accurate, but if you then look at the actual pages cited from Heller and Caetano, it debunks this entire myth entirely, and basically will allow us to win case after case after case, as well as we should when you're dealing with arms bans in America, because there simply is no historical tradition of arms bans. If anything, there's a tradition of no arms bans throughout American history, which makes sense since we have a Second Amendment so important that it found its way into the Bill of Rights. So there you have it. Hope this wasn't too geeky. Hope you learned something here today about analyzing these detailed Supreme Court Second Amendment cases. Don't forget to follow me on X at 4Boxes Diner. We now have over 15,000 followers and growing, talking a lot about Second Amendment there in addition to my YouTube videos here. Don't forget to subscribe and resubscribe. People keep getting knocked off apparently, so I'm told. So make sure you subscribe here at YouTube. All right, we'll see you again soon here The Four Boxes Diner.
Orders up. Table 2A.